Hello, good morning. Welcome to iOS Online Tuitions for Judicial Services. Today we will start with the Negotiable Instruments Act. Negotiable Instruments Act, we will be dealing in Negotiable Instruments Act with the main part of the Negotiable Instruments Act. See, you have actually lot of details in the Negotiable Instruments Act for the definitions, the meanings and all that, okay? But the main part as regards what happens in the court proceedings. That is what we will be dealing with in this session. In this Negotiable Instruments Act sessions. Okay, in the coming sessions. So, Negotiable Instruments Act. Definitions, you can look into the book, but what we are going to do is only the analysis part of this. Okay. So, negotiable instruments. Instruments means anything which can be written. Something which can be transferred. Okay. And what is a negotiable? It has negotiability. Negotiability includes assignability as well. So when you are talking about negotiability and assignability, what is negotiable? Sometimes when we are speaking just like that about let's negotiate, come on. We have the arbitration clause in the contracts also. So what is it about? Let's negotiate, come, we'll sit across the table and negotiate. What is that negotiation? Something which can be exchanged, something which can be negotiated upon. You can exchange one for the other, right? That is known as negotiated. So any instrument which can be negotiated for something else is known as a negotiable instrument. When we are talking about negotiable instrument, the main features of negotiable instruments are negotiability, assignability. Negotiability, as we have already said, it can be exchanged. Assignability means something which can be assigned. Assigned means what? It can be transferred to somebody else. Even though the instrument itself, it's not transferred to anybody else, the interest in the instrument can be transferred. Okay. Transfer of Property Act we read about. Actionable claims, you remember? Actionable claims also speaks about negotiable instruments. So something which can be assigned. Okay, and then we have in CPC, we have it in so many places that negotiable instruments can be assigned. We have the holder in due course. Who is a holder in due course? Holder for a consideration, right? So all this, to whom the debt is given, from whom the debt is taken, the negotiable instrument can be assigned to such a person. Okay. Now this is as far as the introduction to Negotiable Instrument Act is concerned. We will go to the various definitions, of which we will deal only with the meanings. Negotiable instrument, any instrument which can be negotiated for anything else. Then you have the drawer. Drawer is the person who draws the negotiable instrument. Who is the one who is drawing? It is not actually drawing, right? It is writing. The one who writes. So who will be the one who is writing? Obviously the account holder. Okay. Drawing. On whom it is drawn. So who will say, suppose drawer is Jyoti. Drawee will be Jayashree. Okay. So the person whose name is written there, we write it. Sometimes we write it as self. Right. So drawee is the person in whose name the negotiable instrument is drawn. Then you have the payer. the one who pays. The one who pays may be the drawer or may be any other person. How do you know it is any other person? Who will be the one who is paying? See, for example, if I am paying through a bank, payer can be even the bank, right? Drawee can be the bank. Payer can be the bank. Same way, payee, to whom it is paid. Can also be the bank. It can be any individual, any bank, any financial institution. You understand? But only thing, on whom it is drawn, whose name is written is known as drawee. To whom it is paid is known as payee. Drawer is the one who writes. Payer is the one who pays. Clear? These are the differences. Then we go on to holder. Holder is the one who holds the negotiable instrument. When we say he holds the negotiable instrument, it is in his possession. Okay. So, who is the holder? Holder is the one who possesses the negotiable instrument. It can be the drawer, it can be the drawee, it can be the payer, it can be the payee. It can even be the office boy of some company. It can also be some clerk of some company. Right? So, it can be anybody, someone who possesses the negotiable instrument. Next we go to holder in due course. Who is a holder in due course? He possesses the negotiable instrument in consideration. He possesses the negotiable instrument in consideration. Okay? So, negotiable instrument in consideration means what? See, suppose I am giving a check for whatever are the services that I get. For whatever are the services that I get. Okay? Now, when you are buying this, video, you will have to pay negotiable instrument. That is, you will be paying via check, probably. Okay, so however you are paying, then it is for a consideration. So, anyone who possesses, if I am undertaking a service, so I say I go to a hotel and I stay there for probably 1 month or 1 week or whatever it is. And then what? I don't have cash, I don't have a card, so what I will do? I will write a check in favor of the hotel. So, who will be the hotel holder in due course? It will be the hotel, because they are holding the negotiable instrument in consideration. For consideration. Understand? It is a consideration. It is as a consideration that is given there. And then you have holder in honor. Honorarily, a person holds a negotiable instrument. That is also there. Okay. So, what are the characteristics of a negotiable instrument? Negotiability, assignability. And we have already seen the various holders, payers, drawers and all that. Now, we'll go to the next one. That is presentment. See, one thing you should remember. Negotiable Instrument Act comes under the special contracts, right? So, they are also under contracts. So, when we are talking about the negotiable instrument, the negotiable instrument itself acts as a contract. Just like how we have the, say for example, negotiable instruments, check, DD, okay, promissory note, bills, vouchers, bill of lading, anything you want you can take. Anything which can be exchanged for money. That is known as negotiable instrument. So, you have bill of lading and then so many such things, you know, by cargo or airway bill, whatever you have, all these will be deemed to be negotiable instruments. Okay. So, presentment, shares, stocks, debentures, presentment. What do you mean by presentment? When the negotiable instrument check, okay, because that's the most common negotiable instrument, and that is the only negotiable instrument which needs to be presented, okay. So when the check is or can be presented, before whom? Before the payee. When does the drawee give it to the payee? When does he present the check? Usually presentment amounts to any individual or company or anybody to the bank. Am I right? So presentment, when can a presentment happen? Presentment depends upon the date written in the check. Am I right? So it can be on site or after site. When we say on site, that means what? Present dated check. On the specific date itself, the check is dated. If I am giving a check to you today, okay, then if I have to write an on-site check, how will I write it? I will write it in today's date. And you can also present the check today itself, okay. After site means what? Post-dated checks. I am giving the check today, but I have given the check dated some other date. It is a post-dated check. Okay. So after site means post-dated check. On site means present dated check. So when can a check be presented? It depends upon the date written on the check. Okay. See, this is very, very important, because when we file a dishonor case, dishonor of check case, okay, dishonor of check case, then the date of presentment becomes very important. Why? Because the presentment date shows the arising of cause of action. Why do I say so like this? Because, see, for example, check validity is 3 months. All of you know that. If the check is dated, say today's date. What's today's date? 9 January 2019. Okay. Now, if the check is dated today, and then I say today you can go to the bank, I have money. But the person to whom I am giving the check doesn't go today. He goes probably on 11th January or probably 11th February or something like that. Then how will I know what to do? Right? Then it can be cause of action arose on 9th January. That is because it was drawn. First cause of action arose on 9th January because of drawing of the check. Second cause of action arose on 11th January. 11th February, the next cause of action arose on 11th February. Right? So 11th February shall be deemed to be the date for limitation. You understand? So this is how it works. So presentment date is very important because it shows the cause of action. Okay? And who can present the check? Drawee, payee, holder in due course. Anybody can present the check. Self-check is also there, right? So even in self-check, if I am writing a check in my own name, either I can go, or the bearer or the holder, the one who possesses the check, can go to the bank and get it. Even though it is a self-check, the person, that is the holder or the bearer, whoever, it means the same, bearer or holder. So bearer or holder can go to the bank and get the check presented. So what is important is presentment. Who does it? See, if the check is drawn on a person's name and other than his authorized representative. This is common in all the laws, especially the Contract Act. So if I have drawn the check in a particular drawee's name, then some third party goes in and says, please give the check, please honor the check. And the check is not honored, it is dishonored. So the third party, can they file a case? No. Unless it is an actionable claim. It has come to the third party via the employee. We read it in Transfer of Property Act, right? So actionable claims, if it is an actionable claim, if it has reached the hands of third party as an actionable claim, then it is okay. And that too, the judgment should be in favor of me. Otherwise, it will be a problem. Am I right? So all these things are necessary for you to know what is it. So presentment after and on site, and who can present the check. These are all very, very important. Who can present the check? When can it be presented? Suppose it is presented after the validity of the check, validity period of the check itself, 3 months. Then there is no question of filing a dishonor for check case. Right? Dishonor of check case. Okay, why? Because the check has lost its validity. Therefore, no question of filing a case at all arises under section 138A of Negotiable Instruments Act. Okay. Now this is as far as the preliminary is concerned. Now types of negotiable instruments, you know, check, DD, demand draft. Then you have the promissory note. You have the bills, vouchers, bill of lading, airway bill. You may have so many such lists. You know, all these comes under the Negotiable Instruments Act. Okay. But mainly, even promissory note also is main, of course. There is no question about DD because demand draft is given only after we pay the money. So we rarely get any disputes for demand draft. Bills, vouchers, promissory notes, these all come under recovery suits. So it doesn't come under Negotiable Instruments Act as such for the purpose of enforcement of law. Understand? So what comes under Negotiable Instruments Act is check, because this is the most common negotiable instrument which is dishonored. Okay. These all come under usually recovery cases. Now we go to the check dishonor. Dishonor of check. Section 138A of Negotiable Instruments Act, read with section 142 of Negotiable Instrument Act. Some people write even 200 CRPC. Some advocates. Okay. So actually 200 CRPC speaks about the written complaint. Written or oral complaint to the magistrate, right? So it's a general provision. Section 138A deals with the dishonor of check. Okay. Now let us see what are all the grounds on which enforcement is allowed under Negotiable Instruments Act. Usually, how is the grounds for dishonor? Let's write it that way. Grounds for dishonor. What are all the grounds? What do you mean by dishonor? Dishonor means the bank says, no, this is not a valid check. Please take it back. Okay? Or we cannot make payment on this check. Please take it back. That is known as dishonoring. Okay? Now, when the bank does not honor, when the bank does not negotiate the negotiable instrument, when the bank returns the instrument as not negotiable, very important. Okay, when the payer returns the negotiable instrument as being not negotiable. Understand? In that case, the dishonor happens. First one, when the check is tampered with. There is some tampering with it, either there is smudging or something like that. Then, illegible, torn, smudged. Smudged means what? there is a this thing and then this becomes like this. That is smudging. And then overwriting. Crumpled. We know this, right? If we fold the check and then go and give it to the bank person, he says, what is this? Please don't fold it. We cannot negotiate the check at all. We cannot give you the money for this folded check. Go bring another check. If the sign does not tally, he doesn't honor the check, right? 8. Where there is overwriting. Overwriting is already done. Then where the account is closed. Okay. Then number 9. Where there is an order for stop payment. And then last one where there is insufficient funds. Most of you may be practicing lawyers. When we file a case for dishonor of check, what do we file it under? The reason given, insufficient funds. Am I right? So, when we file a case under when we file a case for dishonor under the section 138A, the most common reason is insufficient funds. What? Why? Because having given the check, it is the obligation of the drawer. Obligation of the drawer to keep sufficient funds in his account. Why? Because the negotiable instrument, the check, is a contract in itself. There is no need for a separate 10-page contract and then a check. There is no need. The check itself, the negotiable instrument, any negotiable instrument for that matter, is a contract in itself. Am I right? Even if I have a bill, I can go and exchange whatever I have purchased. Why? Because the bill shows that I have a contract between me and the shopkeeper. Right? So, in the same way, even the check is a negotiable instrument and it is a contract. So, there is an obligation on the part of the drawer or payer. Sometimes drawer himself is the payer. Whatever, however it is, drawer is the payer, right? It depends. So, the payer or the drawer, it is the obligation of the person who draws the bill or pays the bill to keep sufficient funds in his accounts once he draws a check. Understand? But if he doesn't do it, then it becomes an offense. When there is a breach of the obligation, it becomes an offense. Understand? Breach of the obligation to keep sufficient funds in its accounts becomes an offense. Understand? See, tampered, illegible, torn, smudged, overwriting, crumpled, sign does not tally. All these things we can rectify. There is no need to go to court and say, Your Honor, it is tampered with. Your Honor, it is illegible. We don't have to go to court for all these things, right? But when it comes to this, I will tell you about these two. But for insufficient funds, it is very, very common ground, and this breach of this obligation to have money, to keep sufficient amount. When I say sufficient, it doesn't mean that if the bank person says 1000 rupees maintenance balance should be maintained, that is sufficient. Then I will draw a check for 5000 rupees, but I will keep 1000 rupees because the bank person told that 1000 is sufficient. We are not talking about the balance which has to be kept in the bank. We are talking about sufficient balance which should tally with the check amount. If I have given a check for 5000 rupees, I should have at least 6000 rupees, right? So that he can take the 5000 rupees and leave the 1000 intact. Clear? So this is what? This is the obligation which needs to be followed in insufficient funds. If this is not followed, then it becomes an offense. So obligation of the drawer is to keep sufficient funds in tally with the check amount. Understand? So if he does not keep, then it amounts to a breach of the contract. But what happens in case of check? The breach of the check becomes an offence under section 138A of Negotiable Instruments Act. Okay, thank you.